Good morning, Mr. Salas. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. So, okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled to the left hand with grass speeding, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all four tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness' tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed the Water Creek, then climbed the fence attached to private residence. And fled on foot for approximately 0.4 miles before he was later detained by his police department and turned over to deputy. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant had red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, noticed to be represented cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety test.
Here's where it gets juicy. He admits to cocaine use, agrees to some tests but refuses others, and gives a shaky story about heading to a girl's house. Legally, the officer's observations, red eyes, slurred speech, odor of alcohol are classic indicators of impairment. But notice the defense pushing on what exactly proves he was driving. This is where courtroom nuance hits. Proving operation versus mere presence can make or break a case.
Someone's house. I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
If you can.
Yeah, all I heard is going somewhere. It doesn't say he was driving.
Sometimes the DUI, they might refollow, but might have been the wrong corner. Sometimes they fade in, it's getting to go.
I'm not sure, Your Honor, there was anything additional. This is kind of like in this mirror.
Hey, look at
Good to
it.
see you again, Your Honor.
Yeah, what's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up my point.
Congressman Bono, Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said that RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers from immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation still.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him and allegedly
He said a Mexican driver swerved in front of him. Is that what he said?
told him no tango papeles or I don't have papers. Salas said the other driver was in a gray Toyota telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink. So
Yeah, I mean, I think if they,
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
They say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstances, that it was a driver. I don't know if the witness actually saw him driving. What we have to prove the driving facts is that Reeves fired to a police prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. It was found nearby. Was observed coming out of the grass nearby. We can find him with a driver.
Although it's an admission, Judge, there needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision.
All right, folks, pause here. Notice how the judge just found no probable cause, even with the defendant admitting he was driving? This is a key moment in legal procedure. Probable cause isn't just about confessions. It's about evidence supporting the crime. So the judge is essentially saying, we need more than words. We need proof. Now, quick question for you viewers. Have you ever wondered how many DUI stops get dismissed at this stage? Drop your guesses in the comments.
Talk to me.
Desnick Smith. He's one of the ones that,
Yeah, ones, okay. What's the last name?
Smith, Desnick, did you do? Out of Louisiana, one of those four guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't, he has a computer, I don't. He looks awfully young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable? Right.
1,500 would be reasonable.
Then he's coming back in.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith, please, bring up Mr. Smith.
Okay, yeah, we're on Smith.
Okay.
Smith's coming out now.
Black claims that they told them they were not going to mess with it. But we'll still wait for the official word from Florida. What's that name of that city?
I don't know that, I just went by the county.
It's another one of those.
I've been mispronouncing,
Natchitoches.
I've been mispronouncing
I
county.
know.
Morning, Mr. Smith. How's jail?
The worst experience of my life, bro.
Makes me really happy. It's supposed to be. You know, the idea of jails are that you learn. And unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this, this car.
Yes, sir.
Your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things that I consider is, number one, are you going to go back if we set you a bond? Number two, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that.
Yes, sir.
So, Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video. State would be opposed to a bond as state considers him a flight risk.
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Madison, Louisiana. I talked to his wife and his girlfriend.
His wife?
Mother. That's what I-
23?
That's what I
His
call it.
mother and his girlfriend, okay? I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's, and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time you will not get another one. Do you understand?
This is a textbook example of how judges weigh flight risk and public safety. Mr. Smith's interstate vehicle theft and prior record put him in high risk, yet the judge still balances that with a chance for rehabilitation, $1,500 bond, clear conditions, and strict warnings. Notice how this mix of accountability and opportunity is intended to keep him out of further trouble while protecting the community. Now, I want you to think, would you set a similar bond in this scenario? Could you see yourself making this judgment call?
Really in college?
Yes, audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith,
Yes, sir.
don't disappoint us, man. Do something with your life. Don't become another statistic. $1,500 and then do right, man. It's not hard in this life, you know? All right, we got you, buddy.
Thank you, Judge.
So if he can make it, I'll print out the reset for him to